We're here for oral argument in case number 1 CACV 180149, Tempe versus Sussex. These proceedings are being audio and video recorded, so we would ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if it's desired. We have read the briefs. We've discussed this case in conference this morning. And counsel, you may proceed.
Thank you, Your Honors. May it please the Court. My name is John Willenchik, and I represent the appellants, Stephen and Virginia Sussex. The issues on appeal here sort of multiplied at the end stages of the trial court proceedings. Originally, it was a very simple issue that the court dismissed the case on the grounds of statutes of limitation. And I don't have much to add to what we've stated there in the briefs. I do think that is a simple issue. We are defending this case. Stephen and Virginia Sussex were defending this case. There is no such thing as dismissing a defense based on a statute of limitations.
You call that a defense, and when we talk about what an affirmative defense is, wouldn't you have to present a valid defense? And if that defense were time barred, it wouldn't be a valid defense, would it?
I struggle with this concept of a defense being time barred.
And I will tell you, I've struggled with it a bit too. So when we talk about a defense, we got to put it in a more simple context. So if we put it in the context of something like defense of property in a criminal context, but there was no property involved or the statute had run on that. So it's not a valid defense, meaning you couldn't raise it to get rid of the underlying issue. I can't even think of a good example. Can you?
I can't, and that's the problem here. Because when we talk about defense, we're talking about an element of the plaintiff's claim. The plaintiff's claim here was for ejectment. It is to remove Stephen and Virginia Sussex from this property. And as an element of that claim, the plaintiff has a burden of showing that it has the burden of showing title under the statute and under the case law and under the common law. So we're talking about here as an element of the plaintiff's claim.
So the
when we talk about
plaintiff
defense.
has quitclaim deeds to this property.
The plaintiff recorded a quitclaim deed, correct.
Which
was recorded when?
It was recorded when?
When was it recorded?
In the early 2000s. That's
2002.
2002, I believe that's correct. Our defense to that element of the plaintiff's claim is to say that is a void deed. That is an invalid deed.
Okay, then let's talk about mayor school district. When we talk about the statute of limitations, it's directly on point between when you knew or should have known. Undisputed statement of facts includes a letter that says your client knew absolutely about it prior to the statute running.
Well,
Year prior to the statute running, which is important.
and it's important what statute we're talking about. We're talking about the statute 12-821 that talks about actions against the state. And we are not filing action here. The state filed an action here. So I think
It's an action to void their title.
it is not. It's a defense to their action for ejectment.
Well, no, you're asking us to rule that they have no title, or you asked the Superior Court that they have no title. That's what you want the court to order, correct?
That they've not met their burden of showing that they have title. Correct.
That they don't have title. I mean, let's not play around. You want them to say, no, you don't have a valid title to this property. You want us to void their title.
When you say void, it's important to play around with that because, again, we'd have to talk about who filed this lawsuit. Who's the aggressor here who filed the action?
Who has title? Right now, today, who has title?
Not the plaintiff here.
Prima facie, who has title?
It is not the plaintiff, and that's their burden.
Well, why isn't there? They have prima facie as their title. They have a quitclaim deed to it.
Which we've argued is void, correct.
Okay, so you want to void their title.
Well, when you say void their title, it sounds to me like a quiet title claim. We're asking for an affirmative declaration from the court that they have no title. We are saying they do not meet their burden of showing title. There's an important distinction there in the fact that we're not bringing a quiet title claim here. In fact, my clients...
You conceded you don't have title to this property.
We conceded we cannot bring a quiet title claim. We tried and failed. That's correct, due to sovereign immunity. What we're saying here is at the same time, on an affirmative action like this by the state, they have the burden of showing title. And they can't just point to a quitclaim deed and say, well, indisputably we have title. You can't talk about that, even though we're now the aggressors coming after you.
Say that, but it is prima facie evidence of title, correct?
Prima facie, I don't know there's any discussion of prima facie evidence in this context for that. I'm concerned about the implications of that because anybody can issue a quitclaim deed to somebody to whitewash title. You always have to look deeper than merely pointing to a quitclaim deed. Even by the nature of a quitclaim deed, it is not affirmatively warranting title.
Well, even if you have, everything you just said, title is still a prima facie evidence of ownership. And then you can contest it, sure, you can contest it, you can do anything, but the law recognizes that they have title to this property.
I disagree with that. I don't think the law does, and that's the issue.
Until it's disputed and it's resolved, they do.
I don't think anybody has title until the court orders who has title. That's the purpose of quiet title.
We transfer property via deed all the time. A quitclaim deed, unless challenged, is a valid deed. You convey whatever interest you hold in the property to the person you quitclaim it to. So if I hold title to the property and I quitclaim it to you, I've given you all right, title, and interest in that property, have I not?
If you hold title, that's correct.
And if I go down and you and I record that deed, which is a quitclaim, I'm giving you my interest, it's of record notice. That's a prima facie evidence that you hold title to this. I no longer do. Agreed?
I see no discussion of prima facie evidence in this context. I mean, my concern with that is I could just walk into court and say, I have title to this. I've been there for many, many, many years, which is essentially what the Sussexes are saying, and that is prima facie evidence of my title. I don't know that the law recognizes a special distinction having a quitclaim deed as opposed to saying, based on adverse possession, for example, I have title.
Adverse possessors don't appear in the record of title that can be searched by a title agency. Adverse possession is a claim in equity. Transfer of title is a transaction in real property regardless of the kind of deed conveyed.
Correct.
So when we see the difference there, Tempe needs to recover on the strength of their title.
Correct.
Okay. They have a quitclaim deed.
Correct.
Your client has no documentary evidence.
No documentary evidence, correct.
You've conceded that he does not have a claim for adverse possession.
Can I just qualify? I apologize. No recorded documentary evidence, correct. There is documentary evidence.
Okay. You've conceded that he does not have a claim for adverse possession. Is that correct?
As against the City of Tempe due to sovereign immunity, correct. As against the UPRC, not correct. There is a claim for adverse possession there.
Explain that one to me.
Sure. The city has taken the position in this appeal that its entire claim, that quitclaim deed, is based on the UPRC's title.
UPRC.
United Pacific Railroad Company.
Let's just make sure we know what we're talking about. I like to call them the railroad.
The railroad.
Okay.
Our clients do have a claim for adverse possession against the railroad that occurred by operation of law. In other words, they didn't have to record anything, and they didn't have to go to court to establish their claim.
Okay, so if we take that as true, you've argued two different things here. You've argued a void title, and we've asked you about the statute of limitations and there being a record title holder, and you said you're not trying to void their title, you're using it as a defense.
Correct.
For it to be a valid defense, wouldn't you have to at some point be able to void that title?
No, because, and I'm glad we progressed this point in the conversation because in the argument, because on appeal they've abandoned the argument. The city has abandoned their argument that they got title from the state, and the voidness that all had to do with invalidating title of the state. They've taken the position in this appeal that their title derives from the United Pacific Railroad Company. And to answer your question, there's no need to record anything to establish title against the United Pacific Railroad Company.
Okay. And let's just make sure we've all got this. A, the land department transferred to B, the railroad transferred to C, the city of Tempe.
Correct.
And you believe that's how it happened?
That is how it happened according to the recorded documents in the record, yes.
And it's undisputed that's how the transaction happened.
Correct.
So this was a transfer between the land department and the railroad?
Correct. From the land department, from the state to the railroad to the city.
So how is your client in adverse possession against the railroad if the railroad owed it for, I think it's a month?
Because the city has taken the position that the state never had title.
But that's not your position.
Well, let me be clear, because there's a basic point I need to get across here. When somebody records a quitclaim deed, they're not establishing a valid claim to title. A quitclaim deed is just a piece of paper that gets filed with the county recorder that says somebody has conveyed whatever interest, vel non, or lack thereof, to me. That doesn't establish a valid claim to title. And the city's in fact taken the position in this appeal, the state never had title. The UPRC always had title. So what we're saying is, well, if the UPRC always had title, then my clients would have voided out that title a long time ago through adverse possession.
But that's not your position. Your position is this: is that it was granted to the state through the land grant, right?
We don't need to take a position on that, Your Honor, because this is a defense to their lawsuit.
Because I find this confusing if you're saying that Tempe didn't prove they have title, and you can't prove that you have title, then who the hell owns this property then?
Thank you, Your Honor, because that's what quiet title is for. Frankly, they should have filed a claim to quiet title and named all the possible owners, including UPRC, including the state.
Let's pause there.
Sure.
And back it up. Your client's already filed a quiet title action.
Against solely the city, correct.
Wasn't, if you really believe the railroad was your previous owner, weren't you under an affirmative obligation to include all persons known at that point in time in that lawsuit?
I don't think there's an affirmative obligation. We should include anybody who's making a claim to title. And based
So
on...
if we talk about the principle of tacking, which is what you would have to use to ever get title, is tack the railroad time to the current owner, agreed?
Tack the railroad time, I think that's operating in reverse. Our client doesn't need to tack, my client doesn't need to tack anything because they have been there for 120 years. He's personally been there for at least 50 years.
Okay.
Yeah.
We can get into the adverse possession claim, but do you even believe that claim is before us?
As a defense to the element of their claim, their burden to show title, it is.
Okay, so explain to me how a claim for adverse possession in a case that's already been litigated regarding adverse possession and this party can serve as a defense against the city of Tempe if you've already lost this claim.
Absolutely. Adverse possession is not really a claim. In fact, adverse possession is in itself a sort of defense. It's defined as a statute of limitation against the record title owner to go after whoever is on the land. So it's not really affirmatively a claim. It's something that happens by operation of law. It's not a claim that we have to bring to court. In fact, we probably shouldn't even call it a claim, but it's an easy way to refer to it. We dropped a footnote into our brief, a reply brief, explain that important point, because that's why when we talk about, well, gee, when they recorded a deed, isn't that somehow making a valid claim, isn't that establishing a valid claim? It's not, because you always have to think about the adverse possessor. And that's just the nature of our law, has been, for hundreds of years. It is the burden of the title record holder, whoever records title, to actually ensure that they're using that property. And that's why merely recording a deed does not establish valid title, because if there's an adverse possessor on the property and they are there long enough that the record title holder does not sue them, again, it works in reverse, then the adverse possessor holds valid title regardless of that deed automatically by operation of law. So to answer your question, we don't have to make a claim here. It is an automatic occurrence by operation of law because it's a statute of limitations that bars the title holder from coming after them.
But you can't raise an adverse possession claim against the city, right?
We cannot affirmatively sue them for title due to sovereign immunity. And that's another quirk that gets thrown into this case, as if it didn't have enough legal quirks. But that is why the fact that they have sovereign immunity, why it's so important to allow us to have our defenses. Because otherwise, due to sovereign immunity, they have no statute of limitations. The adverse possession statute of limitations does not apply to them. They could sue at any time, even decades into the future. And the problem with saying, well, we are bound by statute of limitations, is that they can, and I argue they have here, gotten around those by waiting to sue until our private statute of limitations have expired to make an affirmative, not that we need to make an affirmative claim, but to make some kind of affirmative claim if that statute applied. They're not bound by that. And we've cited cases, federal cases, that discuss that important point, that they're not bound by statute of limitations and we are. So that's why this whole idea of barring our defense their action based on statute of limitations is completely inequitable.
It's the two theories. Both cannot be true. Your two defenses. You agree with me. Both cannot be true.
You mean in terms of the
Void
state?
title or adverse possession. Both cannot be true.
Well, both cannot be true. We're talking about two different parties. If the state had title, which, by the way, again, they're not arguing here on appeal, the title would be void. The transfer of title to the city would be void. In the alternative.
And you don't address the statute of limitation issue just because you think this is affirmative defense, and you still haven't got me walking along with you there.
It's a defense, not even an affirmative defense. It is an element of their claim.
Doesn't it have to be a valid affirmative defense? I mean, defense to what? I mean, no one at this point can undo that transaction if the statute set forth in Mayor actually applies. Would you agree with that?
Nobody can undo. There's no need to undo the transaction if it's void.
Nobody can void it at this point.
It's
It's
void by
not
operation.
voidable at this point.
There's a difference between void and voidable.
I agree.
The Enabling Act provides that it's void. So no action needs to be filed. By operation of law, it's void. And again, we're not talking about a claim here. We are not
And
making
now we
a
can
claim.
get into the Constitution and what it's required, the Enabling Act, what's required on the Enabling Act. All of that, great. We can do all of that. But you still haven't addressed the point I keep coming to, which is Mayor School District says 1 year from the time you knew or should have known, we have a letter showing not only did your client know, he had actual knowledge and waited more than a year to bring the action. So how do we rectify that?
We're not bringing action.
He waited more than a year to bring it up as a defense, even.
To an action they filed more than a year later is my issue. How do you bring up defense to something that hasn't been filed?
Well, he could have moved to void that long before then. He didn't need to wait. He did. He waited.
He waited. Well, first of all, as we point out as a matter of fact, we did not wait. It was actually less than a year that we got a public records request response from the city that identified this issue, that it was not done by auction. So actually, even if that statute applied, it is less than a year, and we did brief those dates and facts. But setting that aside, the statute applies to actions. We're not bringing action. It's not even an affirmative defense. It's a defense to their burden to show title. And we're saying, you don't have title. At this point, they're claiming title to UPRC. We're saying, as a matter of due to the automatic operation of law, due to adverse possession, UPRC doesn't have title.
Is the railroad a necessary party for your adverse possession claim to be properly before the court?
It's not a claim, and the answer is no. We are defending this case. We do not bring parties into this case. The city only brought us in this case. If the question is, should the city bring them into this case, well, frankly, the city could and should file a quiet title action to
Hasn't
quiet
the
this
city
railroad.
filed a quiet title
It has
action in
never
this
done so.
matter?
It is. It did not do so originally. It is not named the UPRC to answer your question, this action. It may have amended later to bring that into this action.
I think there
I don't
was a
think the
motion
court-
to amend the complaint where it was added.
Yeah, I don't think the court clearly went through the analysis there. But if your question is, should the city bring it into that, because, again, we're not making that claim.
Why would the city be under an affirmative obligation to bring in a party that may cloud a title to something they own? That doesn't make any sense to me. Who has the duty to make the claim? Your client's on the property, there's an ejection action. Okay, you're using it as a defense and you're saying, we've been on the property for hundreds of years. We can go into, there was a homestead exemption that was rejected, which shows that whoever was the predecessor in interest knew they did not have title. There are a lot of issues in an adverse possession claim. But we go back to who has to raise it. And your client already filed a quiet title action against the city and didn't bring in the railroad. Aren't they precluded from doing that now? How long does this get to go on?
We don't have to bring in the railroad to answer the, I mean, again, we're defending the case, and I don't see why we need to do that. All we're saying is they don't have title. If they want to bring in the railroad as part of their quiet title and say, well, we want an order binding on the railroad that we have title, they could do so. I think it comes back to the Judge Howe's point, which is the argument here is, you know, they don't have title. We may not have title. They don't have title either. And that is a valid defense. I see my time is running out here, unfortunately. So.
Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the Court, Shelley Cutts on behalf of Appellee City of Tempe. And I think the beauty of oral arguments is you always come to the court thinking there are certain points you're going to raise, and you listen, and you realize you're going to raise different points. So please bear with me as I go through my scribbles. But I do think this city's case is very simple here. In this action, the city presented to the trial court 2 quitclaim deeds that were properly recorded, showing that the city purchased the subject property from Union Pacific Railroad in 2002 for over $1 million. The city agrees with the court that by doing that, it made its prima facie case showing that it had a valid, subsisting legal interest in the property, which is what the statute requires. On the other hand, the city also agrees with the court that Mr. Sussex could not show to the trial court that he held any legally cognizable interest in the property at all. He presented no deed, no title, no leasehold interest, no life estate. Because the city made its prima facie case and presented its deeds and showed to the trial court it had a valid subsisting interest in the property, the trial court correctly ruled under the statute that the city was entitled to immediately possess the property it had purchased fair and square, and was entitled to eject Sussex because he had no title to the property whatsoever.
Can I ask you just
Sure.
a procedural question?
Sure.
We're plugging along. You file a motion for summary judgment on the ejection action. You move to amend the complaint while the summary judgment is pending, and then you amend the complaint to add a quiet title action. Do I have the...
Actually, I think the procedural history is a little weird. I'm not sure that's exactly how it went down. So when the complaint was filed, first there was a complaint filed. At some point, an attorney for the city of Tempe, who's since retired, filed a First Amendment complaint. Actually filed a motion to amend the complaint to file a First Amendment complaint. I think that motion kind of sat with the trial court for a while, wasn't ruled upon, was sort of sitting out there in the ether for a long time. I joined the city in May of 2017 and took over the case from there. After reviewing the case, I determined that it was an appropriate case for summary judgment, filed that motion for summary judgment. I think at that point, it may have prompted the trial court to say, oh boy, I have a motion to amend the complaint here. I'm going to go ahead and grant it. I think that's procedurally how it went down.
So where is that quiet title action in all of this at this point?
With respect to the city's claims in the action and what it sought summary judgment for, it asked the court to basically rule that the city owned the property, was entitled to possess it, and was entitled to eject Sussex because he had no right, title, or interest to the property. So I think both of those issues kind of got combined with a lot of the other issues about the Enabling Act and the railroad in the state, which were brought up here. And on that point, there is something I do need to correct in the record. With respect to appellant's counsel, I think he mistook the city's position in the case. So The city has not taken the position that the state never had title to the property. I think in its briefings, the city wanted to kind of go through the history of what happened with this property, because it is a little bit complex, and kind of make sure that it was explained to the court. And when we went through the record, this is what we discovered. That basically, perhaps maybe the left hand and the right hand of the federal government weren't particularly organized back in the late 19th century and early 20th century. So what appears from the record is that the federal government, under the Railroad Act of 1875, I think, gave a right-of-way to that property that I believe covered the entire width of the property to what's now Union Pacific Railroad. We can just call the railroad for simplicity's sake. In 1910, in the New Mexico-Arizona Enabling Act, the federal government also included this parcel as sort of the parcel of school trust lands. If you fast forward to maybe the 1980s-ish time frame, the state actually tried to sell the property. The railroad came in and undid the sale and say, how dare you do this and take action that's contrary to our rights as having this right of way. And that began really an earnest litigation between the state and the railroad that frankly never got resolved and was eventually just sort of dismissed from the court. So what the city's position was in the case is you really had two parties, the state and the railroad, with sort of an incomplete, somewhat competing bundle of rights to the property, right? And while they wrangled with each other through litigation and through their attempts to try to resolve all of this and clear it up, that was a situation that basically enabled Mr. Sussex's continuing trespass on the property, because obviously the whole time the state and the railroad were fighting with each other or litigating with each other, no one was there to eject Mr. Sussex from the property.
So the city does not concede the railroad ever had fee simple title to this tract?
No, it's the city's understanding that the railroad had a right-of-way that it believes covered the entire width of the parcel, but that's my understanding from trying to dig into really what's an old and complex record.
So let's back up. What's going on with the quiet title action? Where is it?
Which quiet title action?
Quiet title action that the city of Tempe filed in this matter.
Right. In this matter, I think the trial court addressed it. I think the trial court basically
They didn't
ruled.
quiet title in your client, did they?
I'm not sure I understand your question.
The city did not quiet title in your client, meaning your client's interest has not changed. It's still a quitclaim deed, two quitclaim deeds, correct?
Yes. Thank you.
Okay. To determine if it's a valid sustaining interest, must we determine who has good title? Because we've got this adverse possession claim, we've got this void title claim, we've got all of this going on, and they may be affirmative defenses, but they are sort of claims to title.
So that's a lot bundled up there. When you talk about an adverse possession action, Mr. Sussex did bring an adverse possession action against the city. That was Sussex 1. That case has worked its way through the courts, and Mr. Sussex lost that particular case. Mr. Sussex, is my understanding, has never brought any adverse possession action against another party, not against the state or not against the railroad. And I would agree with you, Judge Campbell, that from the record it appears that the railroad held fee simple title to this property for like one hot minute, right? Between the time that it bought out the state's interest in the property, when the state and the railroad finally resolved their issues in 2002 and entered into a settlement agreement whereby the state agreed it took title subject to the railroad's pre-existing interest. They resolved it.
There, and let me ask you a couple of questions.
Sure.
I love real property, and I find this fascinating.
I wish I was more of an expert in it, but I'll do my best to answer your questions.
Okay. We have a case law, and I forget the name of the case, where the land commissioner entered into a settlement agreement, and the court determined that was likened to a sale. Are you familiar with that case?
Are you referring to the Mayer case or a different case?
It could be the Mayer case.
I'm not familiar with that particular fact pattern, but for purposes of this discussion, I will take your word for it, Your Honor.
Okay, so Is there any way to challenge the transfer between, at this point, as we sit here, because everybody has standing to bring an action if they think the school trust has been violated, is there any way, as we sit here right now, for anyone to say that that transaction between the State Department and the railroad is void?
So you have,
automatically.
Right. You would have to bring that action under, according to the Supreme Court and Mayor, you have to bring that action under the confines of 12.821, which is, the court noted, means you have 1 year from the date of the sale, or the date you knew or should have known about the sale, to bring an action. That's the statute of limitations. So is there conceivably a hypothetical party who has no knowledge of this who can try to claim tolling? I don't know. That's a pretty vague hypothetical. But for purposes of this case and the parties before the court here, Mr. Sussex certainly cannot, because, as the court noted, Sussex's own correspondence shows that he knew about the sale for years. And he knew about the sale and made a strategic decision with his counsel not to challenge the sale. What he decided to do is bide his 10 years and wait and sue the city for adverse possession. And although Mr. Sussex has claimed in this action that the city here is the party being heavy-handed, I think it's really important for the court to know that the city here it is not the one who really sued Mr. Sussex, right? Mr. Sussex initiated litigation with the city by filing the adverse possession action. Once the city prevailed in that action on appeal, it then sought to eject Sussex because he had no right, title, or interest to the property.
Let's talk about this adverse possession claim. He's now claiming he adversely possessed against the railroad.
Okay. Well, I don't know that that's anything that he raised in his pleadings, but I'd have to go back and read them. I think this is kind of a newly constructed argument much later in the case. It seems to me he based that argument solely on the notion, solely because he misconstrued the city's position in the case, and I think I've already clarified it. I do think, just as Mr. Sussex brought an adverse possession action against the city, which implicitly acknowledged that the city was the rightful owner of the property, if Mr. Sussex wanted to do the same to the railroad, I think he'd have to bring an action against the railroad. I don't think he would have any basis to do that because the railroad had title to the property, as you said, for about a month, for a very short amount of time. So in order for Mr. Sussex, or really anybody, to bring a claim for adverse possession against a railroad, you would have had, I think the railroad would have had to have title for a longer period of time. But again, that's not an action that...
Well, didn't the railroad originally, going through your recitation,
right,
you admitted that the railroad originally thought they had more than just an easement, didn't they?
No, I think...
Or, excuse me, right away.
Right. Is the city understands the record. The railroad had a right-of-way under the Railroad Act of 1875. And the same parcel the federal government made part of the school land trust under the Enabling Act of 1910. As I stand here today, I'm not able to tell you what the railroad thought in its own mind about what it had. I can only share with the court what I believe the record reflects.
And whatever dispute was resolved between the city and between the railroad and the state back in 2002, correct?
Yes. So they resolved their dispute through a settlement agreement, and as I understand that settlement agreement, it's in the record in this case. The state acknowledged that it took title to the property subject to the railroad's pre-existing right-of-way. So that's what they agreed to. So the only insight I have as to what maybe the railroad was thinking or what the state was thinking is based on what they wrote in their settlement agreement. I have no other independent knowledge of what they may have been thinking about when they resolved their dispute.
And then the railroad paid the state some money for the
Yes, the railroad paid the state a little bit over $1 million for to essentially buy out the state's interest in the property. Because I think as long as you had two entities with sort of this incomplete and somewhat competing bundle of rights, that property was going to kind of just sit out there. You know, someone had to get the complete bundle of rights for anything to be able to move forward. And I think that 2002 settlement agreement represents the state and the railroad's efforts to have that happen.
Can you correct me if I misunderstand the record? It seems that the court has not ruled on quiet title for the city. Is it the city's position that by ruling on some judgment on the ejectment that necessarily determines title?
I think what the city believes with respect to this and what its goal was in filing the action essentially was to actually be able to possess and occupy and use the property that it purchased in 2002. The city's been waiting a very long time to be able to occupy the property that it purchased. So in bringing this action, I think two of the primary goals were to be able to obtain possession of the property it purchased and to eject Sussex from the property. I think if there was more action that needs to be taken later on regarding the quiet title aspects of the action, I think that's something the city would be discussing and deciding whether it needed to do anything further.
But you amended the complaint for a quiet title, but then you said in an answer to Judge Campbell that you still only possessed it based on your quitclaim date.
Yeah, as I understand it, the city's evidence of its title are the two quitclaim deeds. I'm not aware of any other evidence out there presently of its title. I hope that answers your question.
So you're not making the argument, and I guess I misunderstood your point, that by ruling in your favor on the ejectment, that necessarily determines title, because otherwise you would not succeed?
I think what the ejectment action does, what the ejectment statute does, is basically what the court ruled, is that the city has proven that it has a valid subsisting interest in the property.
That's superior to Sussex.
Right, and that allows it to occupy the property and eject Mr. Sussex. That's what the trial court ruled.
Sussex.
That's my understanding of the ejectment statute. So I'm sorry if there's any lack of clarity there. In my remaining time, unless you have questions, there are a couple of other things I did want to raise before departing. The first is, and I think the court noted this, Mr. Sussex affirmatively filed a counterclaim asking this court for affirmative relief, asking the court to hold that the state sale of the railroad was improper and that the city does not have title to the property. The Evans case from the Ninth Circuit and the other kind of treatise type sources that the city cited to the court makes clear that once you are seeking affirmative relief in an action, you can't also dual plead it as an affirmative defense to try to get around the statute of limitations. I think that's what Mr. Sussex tried to do here. I suppose that's clever, but I think the courts have already sort of they've decided not to allow that, basically, and say no, that's a ruse, that's a subterfuge, and we're not going to allow that. A couple other points. I do think that Mr. Sussex's counterclaim, challenging the legality of the state and the railroad, is not only time barred under Mayor and under 12-821 for the reasons we've discussed, but I do think it also fails for failure to join indispensable parties. Once you bring a counterclaim in an action, you essentially become a plaintiff. And the plaintiff has the duty to bring indispensable parties before the court. I could not understand in any way how the trial court or this court could make a decision on the rights of parties that aren't before it. So I think that is a troubling aspect of this case, but ultimately may not matter all that much because the claim would be time barred anyway under Mayor and 12-821.
And just so I'm clear, the indispensable parties you're referring to would be the railroad and the land department?
The railroad and the state land department. That's who that counterclaim is against.
One is the railroad never owned the property in fee simple, and the land department had an improper sale to the...
Exactly. And finally, this hasn't come up yet. It is briefed, but I just do want to mention that Sussex's final claim is that he's entitled to compensation upon his ejectment. And I just want to point out to the court that the law is clear on that point, and a trespasser is not entitled to compensation upon ejectment. And I think that's especially true in this case because Mr. Sussex never owned, didn't build, and didn't pay to build the 19th century adobe structure on the property that he's now claiming compensation for. So unless the court has any additional questions, I'll conclude as I see my time is about expired.
Thank
you for your time today.
Thank you, counsel.
Thank you, counsel. Rousing discussion.
The case is deemed submitted. We will take the matter under advisement and issue a decision in due course. We are going to take a short recess between arguments, and we'll be back here in approximately 5-10 minutes.